So, Mr. Morgan, I think it was probably about a year and a half ago, we shot a little video about Maximum Allowable Cost, MAC Appeals. You are the leader of our MAC Appeal group. Tell us what's going on in the world of MAC Appeals.
Yeah, so you're right. It's been a little while since we last talked about this, but a lot's happened over the last year and a half. And, when we last spoke, we were really honing in on the MAC appeal, and I can't emphasize enough how important it is for pharmacies to stay vigilant, to be engaging in the MAC appeal process, whether that's directly with the PBM through their PSAO or also through legal counsel where appropriate and necessary, and we're happy to talk to any pharmacy about that. But also, there's been a lot of activity at the legislative level. And I think what that shows is that this is really an important issue. And there's a couple of different factors that go into that. So one thing that I like to point out is states are enacting or amending existing laws regarding maximum allowable cost reimbursement all over the country. And it's being done in a bipartisan way. So I think anytime something's done on a bipartisan basis, that signals to people that, that's a really important issue. It's a high priority in a particular state. One of the other things we're seeing is that a lot of these laws are really capturing the real issues. So for example, one thing we're seeing is how do we define a maximum allowable cost reimbursement, and how do we define the generic drugs that they apply to? So for example, in the state of Michigan, there is a bill that just went through the House. It's being considered by the Senate, and they had a really specific and distinct definition for multi-source generics being reimbursed by maximum allowable cost, and it required that to be reimbursed under a MAC rubric, if you will, that it had to be both a generic and also a multi-source generic with at least two sources. Mm-hmm. So now we have a distinct law on the books, or potentially on the books, that clearly defines what can be MAC'd and then also what can't be MAC'd. So that's really important. I think the last thing that I would say that's happening is, we know that maximum allowable cost is supposed to apply to generics. You're seeing a lot of gamesmanship with that. One of the recent developments over the last 6 months or so has been the Rutledge case out of the Supreme Court. And that's been a real boost, I think, and a real motivating force to the pharmacies to know that, we might have to fight for this, we might have to work long and hard, but if we keep fighting on these different issues and showing that we're being reasonable, we're trying to do the right thing, we're trying to shop prudently and smartly when we acquire our generic drugs, that we are going to win at the end of the day. So I think when you look at some of the things happening at the state legislative level, at the Supreme Court level with Rutledge, and then also just, reiterating the importance of staying vigilant and active with filing the MAC appeals, there's been a lot of progress over the last year and a half.
True, and I think the point about Rutledge is really important. The United States Supreme Court decided the Rutledge opinion, and essentially the Supreme Court of the United States told states, you have the right to go legislate and to make law in your state about important pharmacy issues like MAC appeals. And so states out there, state pharmacy associations, state legislatures, you can do a lot to help independent pharmacies by enacting these laws. The other thing is, do you see pharmacies actually using these laws? I mean, what percentage of our pharmacy clients do you think are really doing MAC appeals?
Not enough.
Okay.
I mean, I think a short, sweet answer is not enough. You do see some pharmacies out there that are aware of it, but one of the things that I see is they don't know what to do with it, or they don't know how it works. So one thing I would recommend is file all of the MAC appeals that you see fit for a 1 month period, 30 days. Document those, create a good record, give us a call, send them over to us, and we will take a look at that free of charge, and we can assess whether, there's an issue there that warrants further attention, or whether, you really don't have an issue. But I would say, generally speaking, pharmacies aren't doing enough with it. There's great laws that have been enacted over the last several months. New Jersey is a great example of one. New Jersey really bolstered its already existing MAC law and broadened it to cover other types of reimbursement. So, now we start to see some things being addressed at the brand level, also DIR fees, GER, BER, so on and so forth. But they're really good laws. They're out there. They're on the books. So you got to take advantage of them. And if you're confused at all about how to do that, again, give us a call and we can talk through your plan of action.
And one thing that I will add to that is that the PBMs are not following these state laws. And we go to them and we challenge PBMs using our tool is state law. and we use it, and we're having some success doing that. So pharmacies out there, be aware of these laws, use these laws, state pharmacy associations, enact more laws that help your constituent members. Thank you, Lucas.
Thanks, John.